Hello, this is Matt on the Moon Lambo channel. Last night, Ripple wrote a letter to Judge Torres having specifically to do with the final portion of the SEC v. Ripple lawsuit, the remedies portion of the lawsuit, and its supplemental information because of a recent development which I highlighted the other day. And so it's described here by attorney James K. Filan of the XRP community as follows. Ripple files notice of supplemental authority regarding Terraform Labs consent judgment. So I'm going to run through this real quick. It's just a quick update. And I got some perspective from attorney Bill Morgan on this as well. But before going further, I do want to be clear, I do not have a financial background of any kind. I am not offering financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, a minimal amount of table setting here. I did cover this in a video just the other day, but you do need to know this in order for the rest of everything to make sense. Here's a June 12th headline from CoinDesk. Terraform Labs, Do Kwon, agree to pay SEC a combined $4.5 billion in civil fraud case. And I'll just run through the 3 bullet points. That'll be sufficient for the purposes of this video. Number 1, Terraform Labs and former CEO Do Kwon have agreed to pay the SEC $4.5 billion in disgorgement, prejudgment interest, and civil penalties. And I will also pause to note here, Terraform Labs, the Terra Luna situation, if you were around at the time, you'll recall that this is the first major problem when things started to collapse in 2022. Remember the market started to tank? I guess it was May, if I'm not mistaken, beginning or middle part of May, I want to say. Market started just tanking, and then it set off this chain of events with a bunch of other firms in the world of crypto just absolutely collapsing, including Celsius. There's the whole BlockFi thing. There's lots anyway. Bullet point 2, the settlement must still be approved by the New York judge overseeing the case. And number 3, the agreement would also permanently ban Kwon and Terraform Labs from buying and selling crypto asset securities. And so when I covered this in a video yesterday, I was kind of laughing a bit because crypto asset securities don't exist. So as part of the deal, he can't sell something that doesn't exist. A crypto asset security, there is no definition for that. It doesn't exist anywhere. It's just a thing the SEC said, so that kind of made me laugh. But anyway, they could, they could have been precise too. If they really wanted to stick that in for some reason, even though obviously he's, they already settled, fine if they were going to do it, but you should have just said something along the lines of, don't break the law by selling investment contracts when you're not registered to do so. And I'm speaking as a layperson, something like that, because investment contracts exist, but crypto asset securities do not exist. Stuart Alderati, he shared this story also, and I mentioned this as well. He's, of course, Ripple's chief legal officer, and he said, this SEC is again touting a big penalty, but the SEC actually will end up with a creditor in bankruptcy court. See BlockFi. The SEC has become a show regulator chasing headlines rather than good policy. Right. So, what does money go to the SEC first, and then anybody else that's in line as a creditor? Like, how's this working? So let's jump into this now. And again, shout out and credit to attorney James K. Filan for sharing this. Now, this isn't very long, so I'm going to run through the whole thing. This is what Ripple's attorneys actually wrote, and I'll share some thoughts along the way, or it's very easy to understand, actually. So again, this was filed last night, June 13th. Reads as follows. Dear Judge Torres, Defendant Ripple Labs, Inc. respectfully submits this notice of supplemental authority relevant to its opposition to the SEC's pending motion for remedies and entry of final judgment. On June 12, 2024, the SEC sought approval for a final consent judgment in SEC v. Terraform Labs. The SEC's request follows a jury verdict finding defendants Terraform Labs, PTE Ltd., and Do Kwon liable for intentionally and recklessly orchestrating one of the largest securities frauds in U.S. history, end quote. And I want to point this out. You might have thought of this on your own, but there's not a single fraud charge against Ripple. And this is actually an important point as we go further into what Ripple's attorneys wrote to Judge Torres here, because we're talking about, in the case of Do Kwon and Terraform, massive actual fraud leading to the collapse of an industry temporarily. Obviously, you know what happened in 2022, culminating ultimately, because, this all played out, one domino hitting the next, culminating in the collapse of Ponzi scheme FTX. So I'm glad the Ponzi was found. And don't get me wrong, of course, I'm glad that happened. But in terms of the degree to which it harmed people materially, financially, yeah, kind of big AF, don't you think? So a little bit different that versus Ripple, no fraud even alleged. And believe me, if there were anything that the SEC could have charged them for that would have been even close to sounding like fraud, they would have done it, because they're a bunch of asshat pricks, spawns of Satan over there at the SEC, flying around, winged creatures. So they definitely would have done that. Couldn't find a damn thing. So that's why we go a little bit further in this, you'll see what the penalty is for Terraform and what it is for Ripple in terms of degree doesn't make sense. So anyway, let's keep going. Specifically, specifically defendants engaged in 2 long-running, massive fraudulent schemes, and that's a quote, in which they, among other things, touted fictitious transaction data to potential investors and secretly supported the price of a token through a high-frequency trading firm while making false statements that the token's price had instead risen due to defendants' proprietary algorithm. So, folks, clear market manipulation, false claim. This is actual fraud right there. And then they say, as a result of these schemes, more than $40 billion of investor funds were wiped out. $40 billion. Remember that figure, please. The proposed consent order requires Terraform to pay, and I'll use round numbers here, $3.58 billion in disgorgement. In seeking this amount, the SEC cited direct witness testimony of investor losses. The proposed consent order also requires Terraform to pay $420 million civil penalty. Now, I just point out here, so they had, cited here by Ripple's attorneys, the SEC had direct witness testimony of investor losses. I just want to point out, in the SEC v. Ripple case, no one was financially harmed, like literally, except for because of what the SEC did, that harmed the XRP markets, so that did. But in terms of what Ripple did, there aren't even claims. Like, none of Ripple's customers suffered financial harm. There isn't even, like, even the SEC in the SEC v. Ripple case isn't alleging that it directly did. Isn't that kind of something? Anyway, so, but here's where it gets real interesting, because in terms of proportionality, which is what we're really getting at here, let's get to the heart of this thing. This is where it's way lopsided. Check this out. Ripple's attorneys continue. This civil penalty represents approximately 1.27% of defendants' $33 billion gross sales. Copies of the SEC's proposed consent order and accompanying letter brief are attached for the court's convenience. The civil penalty sought by the SEC and Terraform demonstrates the unreasonableness of the civil penalty sought by the SEC in this case. As Ripple's opposition explained, in comparable and even in more egregious cases, the SEC has agreed to civil penalties ranging from 0.6% to 1.8% of the defendant's gross revenues. Terraform fits that pattern. Here, by contrast, the SEC seeks a civil penalty far exceeding that range, even though there are no allegations of fraud in this case and institutional buyers did not suffer substantial losses. Terraform thus confirms that the court should reject the SEC's disproportionate and unprecedented request, and that an appropriate civil penalty would be no more than $10 million. And so that's what they wrote there. So think about that. And they're just citing facts here. In terms of the percentage of gross sales, as it pertains to that case and Terraform, it's within norms based on the precedent set because of SEC prosecutions. It just is. There's nothing weird about that. Now, you could sit there and argue all day, like, are they actually going to get those funds? Well, I mean, I said the other day, I don't think that's going to happen. I don't think that they have all of that funds, obviously. But in terms of what the penalty is on paper, is that normal? In that case, yes. But this is why it's so interesting how severely out of whack it is when it comes to the Ripple case. So check this out. You want to know how much worse it is? Well, check out, this is perspective from attorney Bill Morgan, and he laid it out here. He says, this supplemental authority draws attention to the strange animus that the SEC continues to show towards Ripple. Ripple alleges in its remedies opposition brief that the range of penalties that the SEC accepted in other crypto-related cases was between 0.6% and 1.8% of a defendant's gross sales. In the Terraform case, in which a jury verdict found one of the largest securities frauds in U.S. history, involving two long-running fraudulent schemes, and which wiped out $40 billion of investor funds, the SEC accepted a consent judgment for a penalty equal to 1.27% of Terra's gross sales. So folks, as I was saying, that's at least within normal parameters. So why are they being so harsh on Ripple? Because check this out. This is how bad it is as far as what they're expecting from Ripple. So Bill says, against Ripple, in a case in which there was no allegations of fraud and institutional buyers suffered no losses, the SEC seeks a penalty of $876 million, which Ripple alleged was 20 times more than any other penalty in crypto-related cases at that time. The behavior of the SEC towards Ripple is very ill-motivated. Well, damn straight, Attorney Morgan, hitting the nail on the head with that one for sure. And just think about that. Literally no one suffered any losses, no institutional buyers here, because of anything that Ripple did. And still they're seeking a penalty there of that large. Like this just, and in terms of proportionality, like I was saying, it's way out of whack. And so that's why I'm sitting here thinking, if I'm the judge and I know this is what those asshat pricks over at the SEC, those winged spawns of Satan, are saying would be fair and reasonable, I'm thinking, yeah, it's your damn mind, son. It would be, like, if I were the judge, if I were Judge Torres, I'd be thinking there is something else at play here. Like, that demand of that much of a penalty from Ripple, there's no way that that's an intellectually honest request. Like, they think that would be just. There's no way they think that. And if I'm Judge Torres, I'm thinking they have the damn minds. So, I mean, we'll see what ultimately happens. I don't pretend to know exactly how big the penalty will be. I do recall that, a few months or so ago, I know Attorney Jeremy Hogan was predicting that perhaps it would be like $100 million. But still, that would be way less than what the SEC is asking for. And still, even that, though, it's just so fascinating to me. Like, that type of penalty in a case where literally none of the clients suffered financial loss? Okay. Don't make no sense up to me. But it just is what it is. There's also this. Attorney Mark Fagel, a former SEC attorney, responded to that post from Attorney Morgan, and he said, of course, those are settled cases. That's the benefit to a defendant of settling. Plus, in Terraform, it's not real money. The money is gone, so the penalty is kind of a fiction in any event, which isn't to say the SEC will get anything close to what it demands here. Okay, well, here's what Attorney Morgan said in response to that. I accept that there should be leniency for accepting liability and settling, but Terraform only settled after a jury trial, and it was a mega-level fraud, even by crypto standards. Yeah, so I think that's the more powerful point right there. And also, even though, yeah, Ripple didn't settle, well, they obviously, they didn't do anything wrong as it pertains to XRP. I know what Judge Torres found on the institutional side, which frankly isn't going to be that big a deal for, it doesn't matter at all for any XRP holder specifically. But, I understand Ripple didn't settle, but then to have, like, it still doesn't change the fact that the level of disproportionality is extreme here in terms of norms. It's way out of whack. So take it for what it's worth. I think that Attorney Morgan made great points. So that's the latest update. Now, as far as when this ends, Ripple CEO Brad Garlinghouse did publicly state the other day he thinks by the end of summer, which is, he said, September 21st. Attorney Rispoli, I saw a post from him, and he was thinking, if memory serves, more likely to be late July, maybe early August. And these are just kind of best guesses based on experience. So we're almost there. We're less than a month away from the 1-year anniversary of XRP Victory Day, July 13th. Very famous and important day in the XRP community here. So that'll be a fun one to celebrate the 1-year anniversary of that, because we in the clear. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.